Yes, sir.
Ladies and gentlemen, we're going to begin in just a moment. If you can go ahead and silence any cell phones, Kindles, iPads, any sort of electronic device that might make noise during the proceedings. Thank you. All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Welcome. This is Arizona Court of Appeals, Division 1, cause number CACR 120249, State of Arizona versus Gary Lynn Fauché? Fauché, okay. For your information, counsel, these proceedings are being recorded. As you approach the podium, please identify yourself and who you are representing. We are not only audio recording these proceedings, but we are also video recording them, and you will see yourselves on YouTube if you care to look at them in a couple of days. Each side will have 20 minutes to present their arguments, and appellant, you may reserve a portion of your time for rebuttal. If you'll tell us how much time you would like to reserve, we'll try not to horn in on your time for rebuttal. We have read the briefs and have discussed the case in conference, and so we are familiar with the facts and the issues, so you can get right into your arguments if you so desire. And the clock on the podium tells you how much time you have left. If it says you've got 10 minutes, that 10-minute also includes your rebuttal time. So with that in mind, you may begin.
Thank you, Your Honor. My name is Chad Schell. I represent the appellant, Gary Fauché. Your Honor, Your Honors, Mr. Foshee, strongest argument is that he was denied a fair trial. His position is that there were three major reasons that the trial was not fair. There's the issue about causation and possible impairment of the victim. There is the issue in regards to the admissibility of the alcohol retrograde testimony. And then there is the issue in regards to the prior bad act, the prior DUI. Our position is that the strongest argument for a new trial is the causation/victim impairment issue. The evidence was clear, we believe, that the victim could have caused this accident. The victim's actions could have caused this accident. If that's the case, then the possible impairment of the victim is highly relevant to explain to the jury how the accident occurred.
Define your evidence as to impairment. Now, I realize that the state had a witness that got up and said that the amount was similar to a dietary pill.
Correct.
And that there was trace.
Correct.
Please elaborate for us what the scope of the defendant's testimony was, admissible evidence in regard to the issue of impairment, as opposed to just speculation about impairment.
Okay. That same witness, I think it's the toxicologist, Mr. Wade, also testified that the way that the street substance, crystal meth, is commonly used is that people can be on it for days. Now, I understand there's no evidence that he was on it for days, but there was testimony that he had been up for an extended period of time, and that was from one of the witnesses that was riding the bicycle along with Mr. Jenkins, the victim. So the fact that that amount of methamphetamine in the victim's system was consistent with somebody that was coming down off of the drug, and that's according to Mr. Wade, the toxicologist, that he also testified that during the hearing, if he was coming down off of the drug, he could have been impaired due to the residual effects of coming down off of the drug and of being up for an extended period of time.
So because he'd been up for an extended period of time, he may have been on the drug, and if he might have been on the drug, he might have been on his way down, and if he might have been on his way down, it would have indicated the small amount that was in his system? Is that the evidence that you had?
Well, the evidence in regards to the amount of methamphetamine in his system.
As to the issue of impairment.
Well, I believe the way the accident occurred, that he rode out into the middle of the road right in front of Mr. Foshee, reflects that he was impaired. The fact that I think it's common knowledge in regards to how this drug is commonly used and the side effects it has. I think it would probably be impossible to ever prove what his actual impairment was just based upon the levels themselves. It's not like alcohol where there's a presumption that at this level you're impaired, but both the state's medical examiner and the toxicologist both stated that the level was consistent with somebody that can be impaired. And my understanding of the law in this area is that you don't have to prove that the person was impaired. All you have to show is that he might have been impaired. And that's what I think is relevant here. And that helps Mr. Foshee explain how the accident occurred, that he might have been impaired. You're correct that there's no evidence that the victim was without a doubt impaired, but those levels are consistent with somebody that could be impaired. And then you tie that together with the way Mr. Foshee believes the accident occurred and the way the defense expert testified the accident occurred, it would seem to reflect that possibly Mr. Jenkins was impaired. And that's all that we were asking, that the jury be informed that he did have, if the state wants to call it trace, but there were levels of amphetamine and methamphetamine in the system that he didn't have a prescription for, and that it's common that those are ingested through crystal meth.
So the defense expert testimony you're referencing was his opinion as to where the collision occurred.
Correct.
Correct? And the issue here, at least in your mind, is how the victim got to that point in the roadway.
Correct.
And what explanations are there for him to be there? One could be that he simply made a bad decision in the split second in reacting to the lights of your client's car.
It's possible. He could be there because he's impaired. It's not uncommon for people that have been up for days to hallucinate. I think all of that evidence is admissible based upon the fact that the toxicology was clear that he had the substance in his system.
Did you have a witness that was prepared to distinguish between the possible hallucination that you just referenced as a result of being up for too long a period of time versus any methamphetamine impact?
No.
So it would have invited the jury to speculate as to whether he was just tired or actually impaired.
Well, I didn't have the witness, but there was a witness available that would have testified to that, and that was the medical examiner. The medical examiner, and I included it in a motion, the transcript of my interview with him, he said that people with similar levels had been found to be driving vehicles erratically. So I think there was some testimony that we could have called and put in front of the jury from the medical examiner that reflected that the amount of methamphetamine and amphetamine in the victim's system was consistent with somebody that could have been impaired. What the state's expert testified to at the hearing, Mr. Wade, is that the stimulant properties of methamphetamine and amphetamine were not present in the victim based upon the levels. But that doesn't, just because the stimulant properties aren't there, doesn't mean that he's not impaired.
But it seems to me that what the state was saying, and maybe I'm wrong, you can correct me if I am, that because the stimulant properties weren't present, that he wasn't impaired due to methamphetamines. Perhaps if he was impaired because he was coming down and he was tired, it was due to the tiredness, not the drug itself. Is that correct?
That's a possibility, it is, yes. But the defense position is that he could have been impaired from the residual effects of using methamphetamine.
How does it really matter if the defense position, the expert testimony was presented to the jury that the impact occurred in your client's lane of travel? Does it really matter how he got there? I mean, how does the issue of impairment, how does that make that your I understand it was contested, but how does it make it more believable?
Well, I think it explains how, it gives a reasonable explanation for how the victim ended up being in the situation he was in. I mean,
But if it was a given that he was in that situation, why would it matter why he was there if in fact he was riding on the wrong side or riding down the middle of the road? Your client didn't have to prove that he was impaired. All he had to do was prove that it was the victim's own doing that put him in a position where he was hit, correct?
right, there was an intervening, the victim's actions caused the accident, not Mr. Foshi.
So really the benefit from the methamphetamine issue is one of giving the jury something to be offended by, prejudice against the victim, rather than something that supports your client's case, isn't it?
No, I think it explains to the jury why the victim was in that situation. The fact that Mr. Foshi may have been impaired is prejudicial to him, but it goes to show why he was in the situation he was in. So ultimately, one of the positions that we took was that what's good for the goose is good for the gander. If Mr. Foshi's impairment was the cause of the accident, then why couldn't the victim's impairment also be the cause of the accident?
You started by saying something that you didn't have to prove that he was actually impaired, but just that he might have been impaired.
Correct.
Do you have a case that says that? That's an Arizona case?
I think it's Oliver that says that the evidence doesn't have to ultimately prove the issue, it just has to tend to prove a material fact at issue. And I believe it's State v. Oliver. I think it's a Supreme Court case, Your Honor.
Okay.
There's case law, and I think that to me, the law should be simple under this issue. If there are legitimate issues regarding how an accident occurred, then impairment of the actors involved in that issue, in that accident, should always be admissible to show how it could have occurred. And in this case, you have Mr. Foshee, the state alleged and obviously proved that he was under the influence of alcohol when the accident occurred. And it seems only fair that if there's evidence reflecting that Mr. Jenkins, the victim, may have caused the accident also, then his possible impairment issues is relevant and admissible evidence.
So you're arguing that if someone, to simplify the issue, if someone runs a red light and there's an accident, the fact that he ran the red light when he was impaired gives greater impetus than the fact that he ran the red light when he wasn't impaired? And he wasn't impaired?
I think it explains why he ran the red light if he was impaired. If he wasn't impaired, then he was just inattentive to the red light, didn't pay attention.
Go ahead.
Okay. The possible impairment issues in regards to people involved, actors involved in an accident, is relevant just to show how the accident may have occurred. The second issue, the retrograde, it seems that the state seems to think that the defense is arguing that retrograde testimony is not admissible. That's not what we're arguing at all. It is admissible. Ultimately, Mr. Foshee's argument is based upon Rule 702C of the Arizona Rules of Evidence, in that the state's testimony in regards to the retrograde was not based upon valid scientific principles and methods. The state's testimony was based upon a theory that if you drink alcohol, 2 hours after your last drink, you will always be getting rid of it. You will always be, you will not be absorbing alcohol any longer 2 hours after your last drink. That's not true. The studies are clear that people can absorb alcohol for up to 3 hours. Our problem with the testimony in the case was that the range was not scientifically based. The state's expert was allowed to testify about a possible alcohol, blood alcohol level for Mr. Foshee 2 hours after the accident, when in fact that range is a lot wider on the low end and on the high end. And for that testimony to be admissible, it has to be based upon valid scientific principles and methods, and it wasn't. And because of that, it also denied Mr. Foshee a fair trial.
But your expert conceded the fact that that there were a lot of experts in this area that supported and believed to be accurate the manner by which the state's expert presented that evidence, correct?
No, I don't believe that's what he testified to. I believe he testified that it can be done, but it's not valid. Based upon simply upon knowing a blood alcohol level at time X and then trying to relate that back to a time prior to the alcohol level at time X. You need more information. Now, you can get a range for what the alcohol level could be, but that range is a lot larger than the state introduced because their expert did not base her testimony upon reliable scientific principles and methods. And then finally, the DUI, the prior DUI. The state was able to argue, and the trial court believed, that the prior DUI helped prove that Mr. Foshee was aware of the risk of driving while under the influence of alcohol. I think there's two issues there. Number one, Mr. Foshee never defended the case by arguing he wasn't aware of the risk. Number two, it's common knowledge. Anybody that has a driver's license is aware that if you drive while impaired, you're acting recklessly. So the ability to introduce one prior DUI in a manslaughter case, the probative value of that for the burden the state has to prove is drastically outweighed by the prejudice suffered by the defendant, in this case, Mr. Foshi.
Did you offer the state the opportunity that you would stipulate to the issue of recklessness?
No, we never offered the state that.
So there was no offer that you would stipulate to it. You say, although it's common knowledge, right?
Correct.
So the state had an issue that apparently they believed was a part of their case that they had to necessarily prove. And don't we have case law that says that the prior can be used as an illustration, admissible illustration of recklessness?
I believe the Woody case does say that, but it's a second-degree murder case where the degree of recklessness is a lot higher than manslaughter, and the defendant had 7 prior DUIs, not just one. In all of the cases that they cite for this proposition, all are second-degree murder cases, not manslaughter cases, and all of them involve defendants that have numerous prior DUI arrests and convictions, not just one.
Wasn't the defendant in Woody actually convicted of manslaughter as opposed to the murder charge?
I believe so, but ultimately he was charged with second-degree murder, which is a higher degree of recklessness. And to me, when you analyze it, if you're going to argue it helps the state prove that he was aware of and consciously disregarded the risk, then it also seems to be arguing in the opposite direction that the risk is not a risk that reasonable people would perceive. So the defense position is all reasonable people know that drinking and driving is wrong and reckless. To then allow the state to introduce one prior DUI to prove that Mr. Foshi knew it was reckless, the probative value of that, I think, is drastically outweighed by the prejudice. That just because he had a prior DUI and was reckless previously does not automatically mean he was recklessly at this point in time. Your Honors, I have about 2 minutes left. If possible, I'd like to save that for rebuttal.
We'll do that.
Thank you.
Good morning, Assistant Attorney General Michael O'Toole on behalf of the state. I'd first like to start out by talking about the trial court's ruling on the toxicology issue. In the appellant's brief, it seems that he believes that the court excluded this solely on the issue of prejudice, but if you look at the court's ruling, it is clear that the court, and this is on April 18, 2011, at 100 and 101, that the court basically found that in order for the evidence to be relevant, jurors have to speculate. By this time, I think during the argument, opposing counsel had given up the idea that there was evidence that the victim was actually under the influence of methamphetamine at all, and basically kind of was saying, well, this state's expert also testified in general that it's possible under some circumstances that continued use and coming down and those types of things could result in some type of impairment. And the expert did say that as a general matter, but the trial court Judge Harrison noted that there was no indication here of any real specific evidence of the victim's any prior use or any prior sleeping or habits. I think at trial there was some testimony to say that the victim had been up for a little bit, but nothing really substantial. So,
Why were they out riding at that time of the morning?
they were going to a Walmart to get a part for a bicycle. They were, I think it was a chain tool or something.
And the thrust of my question, I wanted to go to the issue of, had they been up for a lengthy period of time, if they were riding at that time of the morning and they were on their store to get a part, was there some lengthy period where fatigue may have been an issue?
Well, and the court never prevented him from arguing that, and certainly opposing counsel did argue that below, and he basically said Mr. Foshi's impairment doesn't have anything to do with this case, but impairment does, and he basically suggested, in accordance with the trial court's ruling, that he may have been impaired due to sleep, or he may have been kind of playing some X Games type of thing. But I don't think it was very convincing, because assuming the victim was up at 6 a.m. and still awake at 2 o'clock in the morning, that's not incredible if it wasn't a 24-hour period or anything like that. So I think it would be speculation to conclude that And he was allowed to speculate. He was allowed to present that argument. He's also allowed to present the argument that the victim was in the wrong lane. You didn't have to show any kind of impairment to show that. People make driving decisions all the time. I don't think every accident is caused by impairment necessarily. So he was certainly entitled to make his argument. He did make his argument, and the jury rejected that. But the point is that the court did rule on both grounds. The fact that evidence wasn't relevant, that's supported by the expert at the hearing who had 40 years of experience in this field. It is also supported by the fact that the meth would have been used over 6 hours prior. It would only had an effect of 4 to 5 hours. So by math, the definition there, he would not have been under the influence of methamphetamine.
Is there a distinction between have effect and impairment?
Between have effect and impairment?
You said after 4 to 5 hours, it would no longer have its effect. Is that different than after 4 or 5 hours? He may still be impaired, but it may not be affecting him?
I think what I'm talking about is the same thing, whether it had an effect on him, was it impairing him at all. I think there is a distinction, though, between you have to get past that. If you could show he was under, quote, the influence, well, maybe I misinterpreted the question. So if the methamphetamine had an effect, I don't think that necessarily shows he's impaired. I mean, coffee has an effect, it has a stimulant effect, but I don't think that shows impairment to any type of degree. And I think here at this very low level, even if he had been under the influence at some level, I don't think he would have been impaired per se. There was no indication that that very low level, even if it would kind of in a system at that time, would have caused him to drive poorly for any reason.
Was there anyone listed that was going to come in and say that based on their analysis, their scientific participation in the matter, that they believed he was impaired?
The only suggestion of anything remotely like that was in the motion to reconsider. As I stated in my brief, in the answering brief, I think appellant has waived this argument. He sets forth the standard review for admissibility of evidence. We had an evidentiary hearing, we had live witnesses, we had the court make a ruling based on that evidence presented and the arguments presented. And then after the fact, the appellant filed a motion for reconsideration based on a little snippet from an interview with the medical examiner that had occurred months and months prior. The Rule 16.1 requires good cause for that. And in the brief, there's no discussion of whether it was a good cause or whether there's a basis for the court to reconsider his prior ruling. So the state thinks the appellant has abandoned that argument. But going to the merits of that nonetheless, we have basically a conclusory statement by the medical examiner. And I think a couple things are very important. One, it's conclusory. It's kind of vague, says he could have been theoretically under. And the two big factors, I think, is number one, we don't have testimony or even a transcript indication that the medical examiner was a toxicology expert. So he might have some general reference, like maybe we all do, about meth is bad and maybe he's seen this before. He seemed to have some kind of knowledge of it, but he didn't set forth any qualifications, unlike the state's expert who had 40 years experience directly relevant to this issue. And then I think at a factual basis, he was talking, from what we can tell, about the level of meth in the victim's system without talking about the ratios, which was talked by the state's expert. And that is the key here, because it shows that the meth had been in the system for quite a while and it had already kind of worked its way out, as opposed to a lower ratio of like 10%. And at that point, then he would have been technically under the influence, and then there would have been another question whether that would have been sufficient to show impairment. And then finally, the appellant filed a motion reconsideration on this issue, but really presented nothing new until he filed the additional statement of facts. That was filed more than 10 days after allowed for a motion for new trial. Motions for new trial must be filed within that 10-day period. It's a jurisdiction requirement. I cited a case in the brief, State versus Ring, which kind of talks about this a little bit. I forgot to cite footnote 4, which basically says that you can't make new arguments in a motion to supplement the motion for new trial and evade the time limits that way. So we think there's no jurisdiction to consider those arguments, but nothing there really changes the fact anyway of the basis for the trial court's ruling. And we must realize too, we're here under abuse of discretion standard, and that requires appellant to show that no reasonable judge would have made the same decision under these same circumstances. And we have the additional fact that in State versus Gibson, the Supreme Court indicated that as far as 403 goes, there's extra deference given to the trial court because it's very hard to quantify those types of things. Moving on to the second issue, appellant's argument really is based on, I think, one expert and one case. The evidence at the hearing kind of showed a difference of opinion, and I think this issue is most easily resolved by reference to the comments to the rule, which the courts have relied on before interpreting rules. And those comments says the court should not pick winners. If there's a question, it should be subject to the cross-examination and not take the issue from the jurors. And finally, on the prior conviction, appellant attempts to distinguish Woody, but as Judge Winthrop pointed out, he was convicted of manslaughter, so we have the same offense. And even though the defendant in Woody had 9 prior convictions, only one was introduced. Woody does talk about the fact that the prior was similar, but in fact, if you look at it, it really wasn't. One was a head-on collision, one was a police chase. I think the court said that because they were kind of quoting from a Ninth Circuit case. Our court, Supreme Court, has made clear since then that it's not a requirement. All you need is a proper purpose under Rule 404B. We have that here to prove knowledge. You have to show it's relevant. It's relevant because it does show knowledge, and it can't be the prejudicial value the probative value can't be substantially outweighed by the prejudicial effect. And a limited instruction must be given here. That was all followed through. A limited instruction was given. The prosecutor argued this very briefly in the opening and the closing for the proper purpose. The jurors are presumed to follow that instruction, and I think Woody is pretty much right on point here.
No concession at trial to the issue of recklessness.
There was not, Your Honor, and I think it is kind of common knowledge that drinking and driving, is a problem. But here, the state didn't have to prove negligence; they had to prove recklessness, which required a conscious disregard. And this basically shows a personal knowledge of this, which is very good evidence for the state.
Thank you.
Any further questions?
Nope.
Thank you.
Thank you very much.
Just briefly, I'd like to touch on the first issue, the causation impairment issue. I think the state is misstating Mr. Wade's testimony, the state's expert. All Mr. Wade testified to was that the stimulant effects of methamphetamine would no longer be present 6 hours after the ingestion of the methamphetamine. But he admits that there are residual effects that easily could have impaired the victim in this case.
What residual effects?
The residual effects of sleep deprivation, the residual effect, ultimately I think it would be sleep deprivation, in that the drug causes people to stay up for extended periods of time, and when they're coming down off of the drug, the sleep deprivation can cause them not to think clearly.
So it wouldn't have been impairment from the drug, it would have been fatigue because he'd been up a lengthy period of time.
Because of the drug.
And you got to argue that he'd been up for a period of time, did you not? Was defense counsel allowed to argue that he had been up for a period of time and the fatigue could have caused his impairment, or could have caused him to ride his bike erratically?
Correct.
And so, really, what have you lost? I mean, you don't have a witness that says he was impaired because of the drug. He might have been impaired because of sleep deprivation because of the drug, but he wasn't stimulated because of the drug.
Right.
Is
The
that correct?
stimulant properties were no longer in play. But I would point the court to Oliver, where it clearly says the evidence need not support a finding of an ultimate fact. It is enough if the evidence, if admitted, would render the desired inference more probable. And that's the point we're making, that the inference that needed to be made was that the accident was caused by Mr. Jenkins' impairment, and that causation negated Mr. Foshi's criminal responsibility for the accident.
Before you sit down, what page was that from? Because I've got that up and I was...
Oliver?
Uh-huh.
158 at 28,
At 28?
or 720 at 1077.
Okay. Thank you
Thank you,
very much.
Judge.
Thank you very much, counsel, for your arguments. They've been interesting. We will issue an order in due course. But for now, we'll take the matter under advisement, and we are adjourned. Thank you.
Nice meeting you.